guys, welcome to my channel. In this video, we'll discuss about legal aspects of business in Unit 2, Company Documents, that is Chapter 4. We'll see the introduction about the company documents. So, in order to get incorporation of a company, promoters have to deposit along with the application a copy of Memorandum of Association, that is MOA, and a copy of articles of association and prospectus. These are the three important things for the company documents. The first one is memorandum of association and copy of articles, associations and prospectus. These documents are called primary document of incorporation. Following are the primary documents of the company. The first one is we are going to see the memorandum of association, that is nothing but MOA. It defines the scope of the company's activities. It is a document that sets out the constitution of the company. The main purpose of the memorandum of association of a company is twofold. First is it is intending the shareholders before making investment in the company should know the field in or the purpose for which it is going to be used and what risk he is taking in making the investment. And the second purpose is that anyone dealing with the company will know without any doubt what the permitted range of the company is. It should be duly stamped, signed by the subscribers, and 2 for private company and 7 for public company, and attested by the signature of a witness. The subscribers to the memorandum are termed as original members of the company. We'll see the purpose of memorandum of association. The very basic purpose of memorandum of association of a company is to make aware its reader, that is generally its stakeholder or investor, of the objects of a company which are permitted under the law. The particular thing that has been discussed in one of the acknowledged case, that is 1918 AC 514. The company cannot act beyond the above said purpose unless approved under the law. Otherwise, it would lead an ultra-virus action of the company. In accordance with the section 245 of the Companies Act 2013, members or depositors can file an application before the tribunal NCLT for seeking an order to restrain the company from committing an act which is violates the articles or memorandum of the company. An investor like shareholder, stakeholder like bank usually checks the memorandum of a company to know about the permitted activities or business to that company to finally decide whether to fund the company or not. We'll see what are the contents of MOE. The first here is name class, and the name class of memorandum shall state the name of the proposed company, and the name of a company establishes its identity and it is the symbol of its existence. A company is subject to the following rules set at any suitable name. That is, undesirable name to be avoided, injunction or if identical name adopted. If a company gets registered with a name which resembles the name of an existing company, the other company with whom the name resembles can apply to the court for an injunction to restrain the new company from adopting the identical name. And the third one is limited or private limited as the last word or words of the name. We can say many private company ends with private or limited, so it is one of the name class. Under the name class, it is one of the rule. The memorandum shall state name of the company with limited as the last word of the name in the case of public limited company, and with private limited as the last words of the name in case of a private limited company. And the prohibition of use of certain names that Impulse and Prevention of Improper Use Act prohibits except with the previous permission of the central government and the company or from with any name or specified in the schedule of the act. The fifth point is use of some keywords according to authorized capital. And the second content is domicile class or register of a class. Every company shall have an office registered from the day on which begins to carry on business. So the third one here is the object class. Object class defines as well as confines the spheres of business activities that the company would engage in. Any activity which is not specifically and explicitly allowed by the object class cannot be carried on by the company. And fourth one is liability class. Liability of members is limited by the face value of shares. And for a company limited by guarantee, this class will mention the amount which every member undertakes to contribute to the assets of the company. For example, not exceeding 500 in the event of winding up. For limited company, this class is not needed. And fifth one here is capital class. This class states the amount of share capital with which the company is registered and the mode of its division into shares of fixed value. That is, the number of shares into which the capital is divided and the amount each share. If there are both equity and preference shares, then the division of the capital is to be shown under these two heads. And the final content of MOA is association class. At the end of the momentum of every company, there is an association or subscription class or a declaration of association which reads something like this. We, the several persons whose name and address and occupations are subscribed, are desirous of being formed into a company in pursuance of this momentum of association, and we respectively agree to the take the number of shares in the capital of companies set opposite our respective names. Then follow the names, addresses, descriptions, occupations of the subscribers on the number of shares each subscriber has taken and a signature attested by a witness. And the next chapter is alteration in momentum of association. It includes change in name class and by ordinary resolution, change of registered office, change in object class, change in liability class, change in capital class, and that's it. By special resolution, a company may change its name by a special resolution and with the approval of the central government, change of name. And we'll see the articles of association, the articles of association of company and its bylaws or regulations which govern the management of its internal affairs and the conduct of its business. It defines the duties, rights, powers and authority of the management and the board of directors in their respective capacities and of the company in the mode and form in which business of the company is to be carried out. It consists of some of the contents of articles of association. The first one is share capital. It includes subdivision, rights of various shareholders and relationship of these rights, payment of commission, share certificates. Line of shares means to retain possession of shares in case of member is unable to pay his debt to the company. Calls and shares include the whole or part remaining unpaid on each share, which has to be paid by the shareholders on the company's demand. Transfer of shares. The articles of association include the procedure for the transfer of shares by the shareholder to the transferee. And it includes many contents of articles of association. Just you can search in section 5 and section 5.2 of Companies Act 2013. You will get more information about that. Next we'll see the procedure for alteration of AOA. Thus it consists of 5 steps. The first step here is convenes a board meeting to alter the article of association of company by giving notice of at least 7. Step 2, hold the board meeting. At the board meeting, the given resolutions must be passed, get approval to alteration in article of association and recommending the proposal for members' consideration by way of special resolution. And the third step here is convene a general meeting. Check up the quorum and check whether auditor is present. If not, then leave of absence is granted or not, as per section 146. Special resolution section 114 in under the section 2, and approval of alteration in AOA. Step 4 is filing and fees. Um, File form number management 14 with the register along with the requesting filling within 30 days of passing the special resolution along with given documents, that is certified true copies of the special resolutions along with explanatory statement, copy of the notice of meeting sent to members along with all the annexure, and third one is a printed copy of the altered article of association. And the final step, that is fifth step, is follow up. The registrar shall then accordingly register the alteration and issue a certificate which will be the conclusive evidence that all the requirements with respect to the alteration have been duly compiled with by the company, and the alteration shall be complete and effective only on the issue of certificate by the registrar. If the special resolution is not filed within 30 days from the date of passing of such resolution, then additional fees will be levied as per Companies Act 2013. And the final one is incorporate the alteration in every copy of memorandum. And we'll see about the prospectus, that is the company's document, the third document, primary document. Under section 236 of Companies Act 1956, prospectus means a document described or issued as prospectus and includes any notice, circular, advertisement, or other documents inviting offers from the public for the subscription or purchase of any shares or debt of a body corporate. Thus, a prospectus is not merely an advertisement, it may be a circular or even a notice. A document shall be called prospectus if it satisfies two things. It invites subscriptions to share or debts or invites deposits. The aforesaid invitation is made to the public. And we'll see the contents of prospectus. In contents, the detailed description regarding the establishment of the company and its characteristics and its estimated future is given. The important matter includes in the prospectus or follows. First one is brief history and prospectus. It includes brief history of company, main objects of company, and the location of the plant, information about project, plant and its machinery, raw material, and economic justification and marketability of the goods to be produced. Also, it includes the capital structure. Under this head, information is provided regarding share capital, basis of allotment, and facilities available to non-resident for purchase of shares. And the third one is information about the company management, details about the project, financial information, general information, commission, brokerage and tax exemptions, board of directors, interest of directors, and miscellaneous. Next, we'll see the types of prospectus. There are 5 types. The first one is offer document. It means prospectus in case of a public issue or offer for sale, and letter for offer in case of a right issue which is filed with register of company, that is ROC, and stock exchanges. And second one is draft offer document. It means the offer document in draft state. The draft offer documents are filed with SEBI at least 21 days prior to the filing of the offer document with ROC or SEs, that is stock exchanges and register of companies. Third one is red herring prospectus. It is the prospectus which does not have details of either price or number of shares being offered or the amount of issue. Abridged prospectus means the momentum as prescribed in Form 2A under subsection 3 of section 56 of the Companies Act 1956. It contains all the salient features of the prospect. It accompanies the application form of the public issue. And the Shelf prospectus comes under the section 60A of the Companies Act 1956. It permits any financial institution or bank to file a shelf prospectus covering one or more issue of securities or class of securities specified in the prospectus with the ROC. And the advantage of a shelf prospectus is that the issuing institution need not file a fresh prospectus at every stage of an offer within the validity of the shelf prospectus. Normally, the validity of the shelf prospectus is 1 year.